Child custody. A contentious issue in many divorce proceedings. In California, the ultimate goal is the best interest of the child. And when you go into a divorce proceeding, you no longer have full control over the decisions concerning your child. If you don't come to an agreement between yourselves, the court will make a decision. You're putting that decision in the hands of a stranger. The ultimate goal in California is to make orders that are in the best interest of the children. Therefore, you have to be available to compromise and to put your side, your prejudices, and think what's in the best interest of your children. In California, child custody is divided into two sections. One is called physical custody and one is called legal custody. There is no such thing as sole custody in California altogether. California courts will make sure that each parent has contact with the child. Let's talk about physical custody. In California, that's referred to as a timeshare. In California, the policy is that the child should have frequent and continuing contact with both parents. A child is not property. Even though community property laws may require a 50-50 division of community property, children are not property and they are not always divided 50-50. The court will determine what is in their best interest. It may not be in their best interest to have an equal timeshare. Your lawyers and the judge will determine what is in the best interest of the children, how custody is being shared. That's referred to a parenting plan. That may be 50-50, that may be plans where you have alternate weekends, it may be plans when you have alternate weeks. It depends upon the age of the children and the needs of the children, and most importantly, since you're going through a divorce, where both of you are going to be living. And they want to maximize the contact with each parent and minimize the trauma to those children who are now losing the opportunity to see both parents at the same time. That's called a timeshare. Now, legal custody is completely different from physical custody. Legal custody means who gets the rights and obligations to make major decisions about the children's upbringing, which may mean even vaccinations, which may mean where school they're going to go to, what religion they're going to practice. And normally in a household, you make those decisions jointly. Once you're divorced, however, you have to agree. That is referred to as co-parenting. If you're not able to co-parent and the court determines that the inability to agree is detrimental to the children, they may delegate those decisions to one parent. That would be sole legal custody. That means one parent has the ultimate right to make all decisions regarding the child. That's the least likely alternative and the least appropriate for co-parenting. However, if the court determines that the inability to make an agreement does jeopardize the best interest of the children, they will impose that. In California, they usually start off with saying we're going to have joint legal custody and each parent is going to have to agree on a course of conduct. Of course, if you can't agree, then you would have to go to court and the court will determine which parent should make that decision. The court will reluctantly never make the decision for the child, but except there's extraordinary circumstances, will delegate one of those parents to make that choice. That's joint legal custody. In certain circumstances, the court will say we're going to delegate the ultimate decision to one of the parents, which is referred to as tie-breaking authority. So one parent will have to listen to the other parent and determine what that parent has to say and ultimately make that decision. Legal custody can be changed once you have what's referred to as a final order. Again, you have temporary custody orders and permanent custody orders. The temporary custody order will be made upon an initial showing when you file a request for divorce and ask the court to make custody orders. Those are called temporary orders. When you finally reach a resolution of your divorce, those are called permanent orders. That's somewhat of a misnomer because even though it's called permanent, the issue is in order to change a permanent order, you have to show that the circumstances that arose around that order have been changed. What could be that? The child could now go to high school. There could be a move away. One parent can change jobs and change locations. Those are some examples of material circumstances. It's not just that you're unhappy with the way things are working. Child custody means both parents have to think about what's best for their children, not what's best for them. Highly contentious, and the court will intervene if they have to. Hopefully with the assistance of counsel who can tell you what the guidelines are, you will be able to reach an agreement without having a stranger like a judge intervene and make that decision for you.